Excellent, great. Go ahead and introduce you. Greetings, everyone, and welcome to our fine lunch hour talk today. I'm Daniel Philpott. I'm the new director of the Center for Civil and Human Rights, who's hosting our speaker. So I'm very pleased to introduce Carla Arena Ventura, who is our current Fulbright Scholar in residence here and comes to us from Brazil. She earned her master's in international law from the University of the State of São Paulo, Brazil, and her doctoral degree in administration from the University of São Paulo as well. She has many other degrees, which I find very impressive, but those are just the two that I'll mention. Currently, she is an associate professor in the Department of Psychiatric Nursing and Human Sciences at the University of São Paulo at Ribeirão Preto College of Nursing. She coordinates an interdisciplinary research group on global health, law, and developments. And since 2008, she has been the executive coordinator of the global network of World Health Organization collaborating centers for nursing and midwifery development. Her research broadly is on human rights, mental health and drugs, health law, international health and development, human rights education, and social participation and control. What she's working on now is in the intersection of human rights and mental health and mental disorders. Indeed, her talk today is entitled Human Rights and Mental Health, an analysis of the Inter-American Court of Human Rights Jurisprudence. Actually, that's her research project. So her talk is, as you can see. So please join me in giving a warm welcome to Carla Ventura.
Thank you very much. I would like to thank first the Fulbright Commission and the Center for Civil and Human Rights, because it is really a great opportunity to be a scholar here for these 2 months. And also, I'm very honored to have the opportunity to talk to you a little bit and to share some of the research that I'm developing here while I'm a scholar. So my research is about mental health and human rights and the jurisprudence of the Inter-American Court of Human Rights regarding this area, okay? First, I would like to show you the University of São Paulo, some sites for the university where I came from. This university was founded in 1934, 80 years ago. It is a public state university, which means that people do not need to pay anything to go, and there is no tuition for the students. And we have 8 campuses in different places of the state of São Paulo. Actually, the university offers 249 undergraduate programs and 239 graduate programs, including both master and doctoral. And we have about 90,000 students that are enrolled in these programs offered by 48 schools. We also have 4 museums at the university and 2 major hospitals, one that is located in the city of São Paulo and the other one that is located where my campus is. And about 6,000 teachers work at the university. So just for you to have an idea, here we have the 80 campuses of the University of São Paulo, and the one here, Ribeirão Preto, is where I came from. Ribeirão Preto is a city located about 320 kilometers from the city of São Paulo. Just a view of the city. We have 600,000 inhabitants. It is an area really agro-industrial. The place where we have the campus of the university used to be a farm, a coffee plantation farm, and now we have more sugarcane over there. And this university campus in the beginning was mostly for the health sciences, and now it's including other areas, law, administration, economics, music, and other areas as well. That's the University College of Nursing, where I work. So, as Professor said, I work in the Department of Psychiatric Nursing and Human Sciences, and I teach there some undergraduate courses in the area of human rights and the right to health, and also graduate courses in this area and on global health. So it has been a challenge for me since I am at this school, because I used to teach international law in law schools, but then it is a challenge, but also a rewarding experience, because it has been very good to look for this subject, especially human rights and the right to health, through other lenses. So this has been a very good opportunity. And we are a World Health Collaborating Center since 1988 at this College of Nursing. We offer 2 degrees, and I have some courses on both of these degrees. And we also have 4 doctoral and 4 master programs. And what's interesting is that in these doctoral and master programs, they are open for professionals from different areas. So I have working with me as graduate students for master and doctor nurses. I have political sciences, and I have many lawyers working with me. Because in the end, what they receive is a title on master or doctoral in science, not on nursing specifically. So this has been very good. So I think that's also why this university was designated a collaborating center and could host the global network, the secretariat of this global network that I'm work with since 2008, and we are going to finish in our term in July 2014. So this was just a brief overview about the college. Now speaking specifically about this talk, the aim that we have here is to discuss, in the light of the Inter-American Court of Human Rights jurisprudence, violations of the human rights of people with mental disorders and the influence of this jurisprudence on Brazil mental health legislation and policies. So what we see when we look at many of the reports from WHO or from UN is that mental health is a priority if we consider the increasing number of people with mental health disorders in the world. That therefore, mental health disorders include people in all countries, women, men, people from rural, people from urban areas, and among the rich and the poor. Although we can say that among the people that are in poorest areas, the index of human rights mental health disorders, they increase. So traditionally, mental health and mental disorders, they have been seen as manifestations of personal weakness and also caused by some supernatural forces. And we have many misperceptions and misunderstandings about mental health and these disorders. So this creates a stigma and a marginalization and discrimination of these people among the society. And then this vulnerability of these groups increases the number or the possibilities for human rights violations that involves the lack of access to proper judicial mechanisms from these people who do not have access to complaint mechanisms and are not able to stop the violence and the abuse that is being perpetrated against them. So they find a lot of restrictions in the exercise of their political and their civil rights, and also in their ability to participate in public affairs. This increases the economic and the social marginalization of this group of the population. On the other hand, it's also important for us to emphasize that vulnerability does not mean that these people are not capable. and also that they are not passive victims, and there we should find different ways to empower this group and to make them to fully participate in society. And this is first a duty of the state that need to have mental health legislation in place in order to establish the rule of law and to foster social development, empowering this group of people. So what we have when we look at the international level, at the international human rights instruments, is that there are not enough, or we don't have many of these treaties just about mental health. We have a process internally, nationally, within the states of some psychiatric reforms that were enforced, but many countries do not have implemented legislation to protect the rights of the persons with mental disorders. When we look at the instruments that we have binding and non-binding. Regarding mental health disorders, the majority, as we see all of them, are only resolutions by UN or approved by the World Health Assembly. So these are the ones who specifically treat about the human rights of the people with mental disorders. We have also this convention from 2006 that is considered really a big step towards the rights, but it's general for people with disabilities. Among these non-binding instruments, I just would like to emphasize two of them: the general comments by the Committee on Economic, Social Rights and Cultural Rights of the UN, General Comment 5, that was approved in 1996, that included among the right to health, the right to mental health, and also the General Comment 14 from 2000 that was very important because this explained what meant the right to health in the Covenant from 1966. And then the committee stated that the right to health approach includes the right to health, includes also the health care, what means availability, accessibility, adaptability, and the quality of health care. And also that when we talk about the right to health, it's very important to consider the social determinants of health. So these are important instruments that we have that treat this right to health and mental health. In our American system, we have one convention, but general for people with disabilities, and we have this non-binding instrument that is the Declaration of Caracas that was approved in 1990 at a PAHO, Pan-American Health Organization meeting. So this declaration was very important at that time because it stated or established some standards for the care of people with mental disorders in our region. So when we look back at this framework of instruments regarding human rights, what we find first is that there is an absence of terminology. Okay, we have, or we can see there, the use of several different denominations. We see mental retardation, we see mental illness, we see mental disorders, mental disability. And then, this is very hard because it's, who are we talking about when we have these instruments for people with mental disabilities or disabilities in general. Even within the psychiatric area, there is not a one definition or one system of classification of these disabilities. We usually have two of them that are used. So, and the Convention of 2006 for persons with disabilities, this convention does not have one concept of disability because it wants to have to approach as most people as it can, and then it states that this is an evolving concept. what we have them is that this lack of a specific language regarding this group of people makes very difficult to apply some rules for them. And it's a paradox, because I'm stating here that it's important for us to have a common denomination, but also at the same time, when we have this, we have a diagnostic label. So people, they are classified as mental patients, and this is not only a medical category, but is also a social category. And after you are labeled as a person with mental disorder, it's very hard for you to become normal, considered normal again. Another interesting aspect that it's important to discuss is that when we talk about the right to health, the right to health is really broader than only access to health services. But when we look at the instruments and the declarations and resolutions from UN or from WHO, they only focus on access to treatment. Why? Because this is a huge problem. It's within these treatment placements, especially at hospitals, that we have many violations for the human rights of these people. So we also have a very important regional system at the Inter-American region with the Commission and the Inter-American Court to protect and promote the human rights. So the proposal of my research while I'm here is to examine the ongoing human rights violations targeting people with mental disorders that were judged by the Inter-American Court of Human Rights. I collected on the site and I read all the jurisprudence and the sentence that were available at the site of the Inter-American Court of Human Rights. In January 2004, we had there 176 judgments available from these different countries. So the inclusion criteria for this were to be issued by the Inter-American Court and to involve a violation of rights to people with mental disorders. Although we have in the Inter-American Court several judgments that really want to protect the mental health of people violated or with other kinds of human rights violations, we excluded these cases because we really want to see how is the violation of the rights of people with mental health disorders. What's the jurisprudence about this group of people? So this search resulted in just one case. And this case is Damião Ximenes Lopes versus Brazil. So here I just show a little bit of the framework for this research. And we have as the structure the international and the regional instruments of human rights, looking at the right to health and the right to mental health, and then focusing on the Inter-American Court and what we have on the Commission to try to understand a little bit how is the implementation of these rights, considering economic and social context, the legal framework, and also the public policies, and how the state duties to respect, protect, and fulfill the right of health is being implemented in the country. And then we focus on some outcomes and challenges within this process. So the case Ximenes Lopes versus Brazil is a case of a psychiatric patient that was admitted to hospital, to a private hospital, but affiliated with the state at a local that is in the northeast of Brazil, a really small city there. And he was admitted and his mother went to visit him. 3 days after he was admitted to hospital, and she saw that he was bruised, he was bloody, with visible signs of torture. His hands were tied, his nose was bleeding, his face and abdomen was swollen. And he just said to her, "Please, mom, ask the police, call the police, help me." What she did was to talk to the doctor, but he just prescribed a medicine and said, oh, if he will die, he will die. And after she got home, she received a call that he died at the hospital. This family, after this, reported this case to the authorities, to the police, to the Federal Public Ministry, but although the investigation was taking so long to get done, really. And as the state did not take the necessary measures, his sister found in the internet, because it's not very usual for people to know that they can file a petition against the commission. We know that, but she found through internet about this possibility, and she got help from some non-governmental organizations, and then she did that. In 1999, the petition was admitted by the commission on 2002, and then during the procedures, Brazil confirmed its liability regarding the violations to the right of a human treatment and the right to life of Damião. But as Brazil failed to comply, especially with the criminal and the civil procedures inside the country, this case was brought to the court. And during the court procedures, as I said, the state of Brazil acknowledged its liability for the violations of Article 4 and Article 5. And in all of the witnesses' reports and the representatives from the state reports, what we see is that Brazil is telling that we were in a process of psychiatric reform and that we were committed with the protection of human rights, but this is a process that was taking place in the country. So on July 2006, the court considered that Brazil violated the rights to life and to human treatment, and also violated the rights to a fair trial and a right to judicial protection in our courts. This case was very important because it shows how vulnerable this population is and how it's very important that the state takes measures to really protect this group of people. In addition, in the sentence, the court determined that Brazil should make moral and material compensations to the family, and within these non-monetary compensations was the identification of the ones that were responsible for what happened to Damião, and also the implementation of some training programs for health professionals and for people working in the field of mental health. Brazil paid to the family in August 2007 the payments that were established in the sentence. And only on 2010 that the process at the criminal and the civil procedures, the courts, they finished, only in 2010. So when we look at this story and how was this sentence, it's very important for us to understand the context, the economic and the social context of Brazil, and how we, after more than 20 years of a dictatorship that we had, only in the end of the 80s that we had a new constitution, and we had really the affirmation of human rights in the country. And within these human rights, our constitution of 1988 also confirmed the right to health of the population. So the right to health in this constitution was considered a right to everyone and a state's duty, assured through social and economic policies which have the purpose of reducing health risks and guaranteeing the universal access to health programs and services. So in order to implement this, we have the law 88 in 1990 that created what we call SUS, that is the Brazilian Single Health System, that is a public universal health system in the country. And this law establishes what we have, the commitments from the federal states, from the provinces and from the municipalities regarding the right to health. We need to understand that although we have the law, it's really a process working because it's very hard to assure the right to health to the population. Thinking that we have in Brazil 190 million people, we have a huge country and we have 27 provinces or federal units and more than 5,500 municipalities. Our investment in health is not great. We invest 8% of our gross national product, and we still have several inequalities in the country. Although we are considered the fifth economy in growth, we are about the 75 Human Development Index. So it's still, we cannot say that growth has become development or even economic development in our country. So this is the economic context that is important for us to understand how this case and was, how the measures regarding this case were implemented there. So one thing that the law also established is that the health system would be mainly public, but when we had private institutions offering the health services, that the state is responsible to supervise these institutions. So in the case of Damião, the state of Brazil was considered responsible for the care that was given to him at that psychiatric hospital. Regarding the psychiatric care, what we had is that mainly the psychiatric institutions were private in Brazil before the 90s, but during the 90s we have a movement that is called psychiatric reform, and after this movement that was really implemented by psychiatric workers, the workers on the field and psychiatric patients, we had a change from a hospitalization model to a community-based network. And this community-based network mainly is composed by what we have is general psychiatric beds at the general hospitals. We also have centers for psychosocial care on daily time. We have daily hospitals for people, and we also have therapeutic residences. There are places where these people who were institutionalized for a long time, they don't have family ties, they can go and they will have their conditions to live within the community and to really exercise some of their rights. So when we look at the outcomes of the sentence from the court, we see that this was very important and was an example because demonstrated how an international mechanism could influence the protection of human rights inside of a country, showing that people with mental disorders need this protection and need to receive appropriate care in their environments. So this influence was unquestionable, and after the judgment, we have two things that were very important. Brazil initiated a program to access the hospitals, so we now strengthened one annual assessment program that evaluates all the hospitals, and then after that several hospitals, they were closed because they did not keep or not comply with the standards. And the most important outcome was the approval of this law, the law 10 216 in 2001. And this law was approved after 12 years that it was being analyzed in Congress and was approved because of the pressure from the Commission. So this law is very important because it's all about our mental health legislation and the protection of the rights of the people with mental disorders in our country. Although we have these improvements, there are many challenges that we can talk about. What we see there is the number of health services is still not enough for the people, and many people who were discharged from hospitals because these hospitals were shut down, or they stay in the streets as homeless, or many of them went to prison. So this is a big issue also when we talk about these rights. And we can say as well that segregation from society is still a reality. I had a doctoral student. She is a nurse, and she did an ethnographic study at one therapeutic residence to see how the people there, they exercise several of their rights, how this was a facilitating mechanism for them at this residence. She stayed with them for 9 months. She did an observation and interviews, and it was very interesting that she found out that when she was living with the patients from the house, that it was in a normal community, people, they would take their children and come back inside because they were afraid. Or if you are walking on this side of the street, they go to the other side because they don't want to stay with them. And this is something that it's a misunderstanding that we have in society that I talked previously about the stigma and discrimination. It was very interesting that she also asked to these patients, because they had like a history of 30 years of hospitalization, and she asked these patients what did they feel about how was their lives in the hospitals. And then they said to her, oh, well, we had food, we had a place to sleep, but we didn't have no one to talk. The professionals, they only gave us medication, and we had really strict rules, but no other activities there. So they just lived in this way. And the health professionals did not talk to them. And then she asked, well, how did you feel when they said you were going to leave the hospital and go to the community? You know what they said? They were afraid. Oh, we didn't want, at first, we didn't want to leave this institution. Although we know that is an institution that really, when we talk about total institutions, like it's a total social exclusion, for them, it was very hard to think that they could go to another place. And mainly for the ones who, before the institution, they were on the streets. So there was something, and they were afraid of losing this. I had another master student. He is a public attorney, district attorney, and he went to another city in which they didn't have these residences. And in a hospital, the hospital that was his place for the research, they had more than 20% of the psychiatric patients who could be discharged but stayed at the hospital because they didn't have anywhere to go. And he asked it to these patients as well. And the answers were the same. No, we don't know. We prefer to be here. We don't want any kind of other services. We prefer to be safe here. So we have a lot to reflect when we talk about this. There are not enough mental health services in the country, mainly the community health services, and we still have the psychiatric hospitals. But now the assessment for these hospitals is much better than it was before. So among these challenges, and when we see this judgment, we have really a paradox about the legislation that we have, but the real exercise of these people. for their rights. And then we have some points that are very important when we talk about this group of the population. The first one is involuntary admission to hospital, because our law states several steps. It states that we should have a reviewing body, just as you do have here, or in other places in Europe as well. But this does not happen in practice. So we are developing some research about that in the hospitals to see how is the implementation of these reviewing bodies to really allow the exercise of rights. Another issue that is very important is about confinement methods. When we read the judgment, the sentence from the court, this was really considered torture, the way that Damian was tied. But this is not uncommon when we go to hospitals, psychiatric hospitals, because we have a lack of personnel, of specialized personnel, and it's very hard. Sometimes what they do is they confine the people on their bed because they don't have really other things to do. So this is something that is a huge issue that we need also to better understand in order to change. Compulsory treatment in Brazil, mainly for drug users, is another issue that we can that we need to take more care. And one thing that is also a misconception, that usually when we talk about people with mental disorders, we associate them with dangerous, isn't it? They are dangerous to society, and this, the media does it really well, but there are not statistical data that proves that they are more dangerous than others. But what we have is that when they are criminal offenders and they have mental disorders, that they stay in prison for life. That's something. And we have 2 cases at the Commission, one with Ecuador and one with Bolivia, that really are about people with mental disorders that were criminal offenders, that were in prison, and that they had their rights violated. The first one died, and the second one did not die. So it's very important to understand this challenge that we have in this area. We have many others, but this we can point out when also we read the judgment from the court. And on the other hand, it's important for us to think that we need protectionist rules, but also we need to have a balance between these rules and how we implement this in practice in order to have these people to have opportunity to exercise their rights. And one thing that is very important when we talk about the right to health is access. And I talk, the right to health includes access, and within this access component, we have access to information, and information about our rights. And we did several researches with health professionals, mental health professionals, with mental health patients, with families, and what we find is that even the health professionals, they don't know much about what the rights are. And this is very important because it's the first step. But it's not new, because in Brazil, when we talk about rights, people, in the majority of them, they don't know they have many rights. They still don't know. And this is because of our culture and all the period that we had of dictatorship. So this is something that we need to work with. The Department for Human Rights of the Presidency of Brazil did a survey in 2010, and then they interviewed 2011 Brazilians older than 14 years old in 150 cities, 25 states, and in all 5 regions of the country. And they found out in general that 1 in 7 Brazilians, they think that rights are a privilege of a group of the population. 2 in 5 Brazilians could not mention one human right assured by the Constitution. And also that people have a negative image about human rights, because when we see in the media, what appears is that these human rights groups went to this prison to protect the prisoners. So people think that human rights are just for prisoners over there. But when these people were shown some of the rights, for them to say what was the most important, they said, nearly 50% said the most important right is the right to health, followed by the right to education and the right to work. And another thing that was really interesting is that people, they did not mention about their political rights. And then, when we don't have political rights, the other rights can be considered as a favor or a privilege. And when we talk to people, we talk to these patients, they say, oh, SUS, the system, is a favor from the state. That is something that was really, we don't think as we are entitled of these rights yet. Human rights is seen as something for the lawyers. This is also something that we hear, rather than something that is for everyone. And we have in Brazil, although we have in Brazil a really increase in what we call judicialization, or the number of litigations in Brazil are increasing in the last 5 years, mostly regarding the right to health. When we go there and see who are complaining, we see that they are not average population, are just the ones who know about their rights, are just the upper middle class of the population who have access to this process. And then it's a big imbalance here, because it's a huge issue about medications regarding the right, this litigation. And then we have a budget that's strict, and the health system needs to deal with these orders by the judges. And then what we find is that people with mental disorders in all this context still do not have enough power, enough information to really organize themselves to defend their rights. When we talk about the state's duty regarding respect, protection, and fulfillment of the right to health, we are in a process, really. We have the legislation, we have some programs being implemented, but it is still a process that we are constructing or building. And when we look back 30 years ago, we can see that there is a lot of improvement in this process. And we need to think about the right to health as this complex and dynamic process, but a process in which we may transform our social reality, and a process in which we need to empower people or to work with people for them to feel that their rights can be consolidated. And it's very important for us as lawyers and working in this field to reflect and to stimulate conversations about these challenges. Then, perhaps someday it will be recognized that persons who have been diagnosed as mentally ill should have exactly the same rights as other citizens of their countries. Most fundamentally, the rights to live their lives as they choose and make their own decisions. Any special help or protection they may need as a result of their disability should not, or should in no way, alter their fundamental citizen rights. So just to finish, I want to show you we have a group of studies and research on global health, law, and development, and we have a blog You are all welcome to visit our blog and to post some posts there. Health and Rights Without Borders. And in this group we have lawyers, we have medical professionals, we have nurses, and we have people from all disciplines. And it's very interesting, although you cannot be presentially there. If you can participate, you are really welcome. And we have done some workshops since 2012. Really with our group and involving other schools and law schools to discuss this theme. These are just the pictures for this. And just one thing, we have also a league that you can see here, a league from the nursing school, that this league is on human rights and health. So the students, they are organizing, the undergraduate students, they are organizing themselves, and we have a program and a calendar, and they do some work in many institutions as well. Just pictures from the workshops that we held. Thank you very much, and if you have any questions. I don't know if you
We have about 10 minutes or so for questions.
Yes.
So I have a couple of questions, and you alluded to this in your presentation. First, thanks, very great presentation. It's timely. Next month, Special Olympics is organized. The word to end the spread of the R word. I said it kind of wrong, so very timely presentation. I think one of the challenges we've seen in the United States is resources exist, laws protect people. We have laws against torture, we have laws against imprisonment. They apply to people with mental health disorders just as they would apply to the regular population. But the biggest problem, and you alluded to this in your presentation, is that there's no voice for advocacy, that there's a lack of voice for advocacy for these people. And then when there is a voice, or when there is an advocate or family member, they run into privacy laws, very aggressive privacy laws, which are sweeping the globe. So I wonder if your research has taken you at all into how family members or those who do act as advocates for folks that have mental, emotional, intellectual disabilities can get around privacy laws that I mostly blame on lawyers and judges, more so than doctors.
You know, the reality there is different, as I said. We don't have really an organized group for advocacy. We have done some research with families and family members, but over there is the immediate concern, you know. They talk about only the benefits, the social benefits that they have, or they can have as a right, that it's already on the law, but they don't know. So, do you understand? So we have really a long run is to have people being conscious about their own rights. And then what we are doing is at some strategically places like the federal public ministry there, where people can go when they have a complaint but they don't know how to do this. We are working with people that arrive there to talk about the right to health and the possibilities. We also have a project on the public lawyers. I don't have a lawyer, but I can go there, you know, and to find out what are the complaints regarding the right to health, or to try to, and then the next step is we find what are the complaints, and then our next step is to try to work with the communities, to try to see how we can organize ourselves in a different way for our voices minimally to be heard, because they are not. But we are one step really behind. We don't know we have rights. Please.
Thank you for a wonderful presentation. I'm especially interested in the interplay between the inter-American system and Brazil. And so a couple of questions. First of all, you mentioned that it sounded like the main legal reform, the main law was passed in 2001.
Yeah.
That was 5 years before the Inter-American Court's decision, although it was after the filing of the complaint with the Commission. So I'd be interested how much you think just filing the complaint with the commission stimulated reform. Secondly, what kind of evidence is there of that? Are there statements by Brazilian public officials or by official reports of the state indicating that they need to do a reform in order to meet the inter-American standards? In general, the question has to do with to what extent Brazil did this, would have done it anyway, and it just happened to coincide with the case, and to what extent the case stimulated the reform.
What we have is that the reform was happening, but the law did not pass. The Congress was there for 12 years, and this just happened after the Commission accepted the case. That happens. And one evidence that we have is when we read the judgment, we have as one representative from the state of Brazil was this person who was under this reform movement, and in his statement at the court, he said that this case was unfortunately and everything that happened, but after this case had such an international recognition, this helped with the approval of the law. So there is this statement in the judgment from Pedro Delgado, that is this person, that is from the Ministry of Health, that gives us some indication that we had pressure from outside to approve the law. Although I think it would be approved, but we don't know how long it would take, because it was 12 years it stopped there in Congress. And it was a big issue, because when we talk about mental health, this is just not the first priority for any government. Yes?
I have a question. I want to know, in Brazil, in the law, who can decide to send the patient with mental illness to the hospital? Because if other like us, we can decide if we want to go to hospital or not want to go. But if people with mental illness, maybe sometimes you can, even in law, it's like limited liability. So who can decide?
Only the doctor there?
Yeah, like who can decide? This question because in my country it's a problem because some people were mental illness by other people. So government said that you have, so it's like this problem.
No, this is a big issue. Then in our legislation, only the doctors that for any admission is done by doctors. Okay, and you should have an external committee to evaluate this. That we have this in our legislation, but it's not in practice. That's why I said some types of involuntary admission that we need to be more careful about that. And we have this legislation, but the practice is so different. In fact, what happened in Brazil is that now you cannot go to a hospital. Within our system, we have different levels. Then you go to a basic health unit that is not even for people with mental disorders, it's for everyone. And you wait there to see if you have a place at the hospital. Okay? And in my city, that is considered like an economic well city, like in the standards of Brazil. We have people waiting for 20 days in a basic health unit to be charged or to be admitted to a hospital. So you see, we don't have yet many facilities to have these people. Yes?
450 million people worldwide seems to be a huge problem. Regarding the Jimena Lopez case, did they rely just on the general right to health, or did they rely on a specific category of right to mental health? I'm saying this because if there's such a huge problem worldwide, is there a problem, a recommendation that will be made at the regional level? I know you're focused on Brazil, regarding an elaboration of rules regarding this category of people. Mm-hmm. In other words, a specific instrument that will focus on this problem. I know there is one of disabilities, but that seems to be general.
Yeah. It's what I said before, like we have this document, but it's general. So we would need to have not only declarations or resolutions, but one treaty or something that is more specific to this kind of, to this group of people. I agree with you, and I think this is very important. But it's very hard, as I said. According to WHO, in 2020, depression will be the fourth non-communicable disease, the fourth in the world. So it's increasing. But we don't still have these instruments specifically for people with mental disorders. Yes?
I know there's been talk of including mental health in legislation as part of broader legislation rather than as separate. Maybe you may have covered this earlier, I'm sorry if I'm repeating. But do you feel it's better to include mental health in every aspect of legislation, say like labor laws and the likes, rather than having it as a separate entity? Then it exacerbates the discrimination of people if they're not integrated into current legislation.
I think we need both. We should need both to really enforce these rights. We have, because we have the specific one. But like work legislation, and this is something, although we have the legislation, you know, people who have mental disorders and may be stabilized, they take the medication, they are fine, they could go to work, but they are not accepted to work. They are not. And this is the data we have. They don't have access to work after you are labeled as a person who had a mental disorder. And just to tell you, I think we need to find other ways. And there is a teacher at my university from the School of Nursing in São Paulo, the main city, and she does a beautiful work. She does, what she created is some enterprises, as she is the co-owner with the people with mental disorders of a catering bar. And they are doing so well. She works with solidarity economy, and they are doing really well, you know, and showing people that we can work, we have the right to work. But in practice, it's very hard if you don't do like these other arrangements. And although we have the law. Yes.
Thank you very much for your presentation. I have a question regarding the correct understanding about the mental illness, because as you mentioned, maybe we have some misunderstandings about what is to be like have a mental illness, that maybe people cannot decide by their own, or that they are dangerous. And I think that's the core problem regarding their protection as human beings, because maybe that's the problem. We're not seeing them as completely humans because they lack of some like categories or facilities or things that as a normal human person have. So if you could just like expand on that and clarify what would be a correct understanding.
Okay, what we have, I showed in the first slides that I think are the solution, not to talk about mental disability, because mental disorder is one type of mental disability. So I don't agree with us talking about mental disability in general. No. So what we have are two classifications. The International Classification of Disease, number 10, and also the DSM, that is a classification from the United States, from the American Psychiatric Association. So I think the solution would be us to choose, because they have some convergences, and they are still broadened, you know, to include more people, but the psychiatric diagnosis is made with one of them. So I think we should use them, and that's why I talk about mental disorder or mental illness. I don't talk about mental disability, because it's very important to focus for us to really protect these people. So I think the solution is to focus on these two, or choose one of them. One is from the World Health Organization, maybe is the best classification that we have. It's not perfect, but it's something that we have that is more concrete than talking about diseases and illness in general.
Let's have one more question. Is there one? No? Well, join me in thanking.
Thank you very much.